guys, I did tell you that there would be a project in the works, and here is part one of my gun series. And of course, what we're discussing is, can they actually take the firearms from us legally? Number two, what type of measures would be put in place? Other examples of, let's just say, the federal government's overreach when it comes to the topic of the Second Amendment, why the Second Amendment is important, and last but not least, the actual logistics behind this and why it would be an absolute nightmare. By nightmare, I mean nightmare scenario for the government. Now, guys, this video right here is a bit of an extension to a video that I made a long time ago on my second channel, Short Timer Prepping, which, by the way, I will leave a link to in the description box. Of course, we're going to be opening up more takes here soon. As a matter of fact, a take will be released tomorrow about what's going on overseas. But the thing is this right here. When I made that video, it was mostly in reaction to what was going on with red flag laws and all that stuff there. Now, the thing that you need to understand, and will be behind the computer for most of this video, is that this thing needs to be broken down in actual parts. So we're going to talk about some politics behind it, and we're going to cite a couple of very famous cases. Of course, those two cases are Heller, D.C., and of course, McDonald Chicago. Just basic readout, breakdown of the actual case itself. That right there will be coming up in the second portion. But before we get into that, we are in fact going to be discussing what a bill of attainder is. You see, one of the reasons why I chose to remake this video is because, yeah, the bill of attainder explanation was not exactly a good one. Don't worry, I'll be actually explaining what that is. That will actually be the first part of this video here per se. Now, you're probably wondering, with the amount of time, how in the world am I going to fit everything that I said in? Well, that's because we're making this a part series. You see, this right here is going to be the initial politics, and can they actually take the guns away legally? And the second video will come out on Sunday. It will be about instances of which the federal government has, in fact, tried to go after the guns. That right there will actually be a much, much longer project, and I will probably be in front of the camera a lot less time, mostly in cutaway. Of course, that there being the editing version of the Claymore videos. The third one, of course, will be talking about the actual Second Amendment itself, where it actually came from. I know I did a bit of a project on this, but I felt it was kind of lacking, but I do want to do it again. And the last one, of course, would be the logistical nightmare. It would actually be if the federal government actually went out of their way to physically take the guns. Now, as far as the ATF braces and then common nuance, the kind of, let's just say, annoyances that we have to deal with from the federal government, that right there will be discussed more in part two. Now, with that right there being said, let's go ahead and get to part one, an actual reading of what a bill of attainder is. Then, of course, we're going to look at Heller, D.C., and then, of course, we're going to look at McDonald Chicago. With that there being said, let's go ahead and hop behind the computer. Okay, guys, by way of Cornell Law School, what exactly is a bill of attainder? Now, gang, I want to do this part here in particular because in a previous video, I may not have been fully accurate. I apologize for that, but I do think that a bill of attainder does need to be explained. A bill of attainder is a piece of legislation that declares a party guilty of a crime. Bills of attainder allow the government to punish a party for a perceived crime without first going through the trial process. Think TAPS Act. Think red flag law. Just think that for a second. In the United States, bills of attainder are unconstitutional as stated in Article 1, Section 9 and Article 1, Section 10 of the U.S. Constitution. Article 9 prohibits federal bills of attainder, and Article 10 prohibits bills of attainder by the states. Basically meaning that you can't implement one of these even through legislation. The constitutional ban on bills of attainder works to uphold separation of powers principles by preventing Congress from assuring the functions of the judicial branch. Courts have adopted a three-part test to determine if a law functions as a bill of attainder. Number 1, the law inflicts punishment. Number 2, the law targets specific named identifiable individuals or groups. Those individuals or groups would otherwise have judicial protections. Really quick. In the Virginia law that Ralph Northam was attempting to get through, the one that they wanted to sign, but basically would require some form of confiscation. Even if they picked you up on a traffic stop, they could, of course, confiscate your firearm. Even in that case there, that was an extremely unconstitutional bill and more than likely would never have gone through, not even the state Supreme Court, and definitely at the federal level. But we'll talk about the Supreme Court and what would actually happen in the event of these here in a second. Okay, so let's go ahead and finish this up. In Nixon versus Administrator of General Services, the court determined that the punishment for those purposes, for the purposes of bills of attainder, will determine by considering whether the statute, that's kind of an error right there, should be will be determined by, whether the statute would historically be viewed as punitive, whether the statute viewed in terms of burdens and severity, can reasonably be said to further non-punitive purposes. Was that a congressional intent for the statute to further punitive goals? Of course, last updated in July of 2022 by WEC's definitions team. When a legislative act declares a particular person guilty of a crime, usually treason, such bills are prohibited under Article 1, Section 9 of the Constitution. Now, gang, this word right here, civics. Now, I understand that teaching the Constitution to small children could be a bit of a problem. Government, bare bones. Legal process, bare bones, I think should probably go to high school. Same thing with criminal law, criminal procedure, statutory interpretation. However, constitutional law can be taught by parents, and I do think it needs to be taught in schools as well. Basically, what you want to do is give your child a bit of a primer. Okay, that's basically what I'm saying. Go ahead and kind of give them a little bit of information so that way they have a better understanding when they go to college or when they actually see this in real life. But this right here is the key word, civics. Civics, 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 civics. Yes, I said that 4 or 5 times. Now, why did I do that? Because civics is the most important thing that we need to be teaching our kids, not sexual things of that nature of which you've been seeing, especially in the national and even the local news. That type of crap needs to stay out of the classroom. We need to replace it with good old-fashioned civics, so that way our youth are not entirely dumbed down. The Second Amendment. Heller, D.C., and McDonald Chicago are the two most references. However, let's go ahead and just kind of read a breakdown of the actual case. Now, I will be linking more documents in the description box, as mentioned earlier, that will kind of lead you, if you really and truly want to go down the rabbit hole to look at every single aspect, go right ahead and do this. This right here, for the most part, is a simple, bare-bones explanation. So let's take a look at this. Facts of the case. Provisions of the District of Columbia Code made it illegal to carry an unregistered firearm and prohibited the registration of handguns, though the chief of police could issue 1-year licenses for handguns. The code also contained the provisions that required owners of lawfully registered firearms to keep them unloaded and disassembled or bound by trigger lock or some type of a similar device unless the firearms were located in a place or business being used for recreational activities. Now, before I go any further, let me go ahead and say this really quick. If you want a trigger lock on your pistol and you want a law there, I kind of think that's a bit of an overstretch. Now, let me give you an example of what I mean really quick. I worked at a gun store back in 2015, 2016. The store that I worked at, not going to say the name of it, but let's just say that it's a retailer that's beginning to get a little bit bigger. They required you to have trigger locks on the guns inside the store before selling them. That's a different case. Now, me personally, as a gun owner, I'm not going to have a trigger lock on my firearm. Why is this the case? Well, let's take a look at what's going on with Ralph Yarl. Now, I already discussed in a previous video that I think that right there is probably a case of a mistake. But let's just say that this was not a case where somebody had actually showed up to my house by accident. Let's say it was somebody who was actually trying to break into my home. Would you or would you not want your pistol or your shotgun to have a trigger lock on? No, you would not. You would need that weapon readily available for you to be able to fire back. I wanted to go ahead and announce that now. Go ahead and get that out of the way. Having a trigger lock on the gun inside the house. Now, I understand if you have little children, but obviously you're going to need a weapon in that place that is not got a trigger lock on it, so that way you can use it in case you are attacked. So I just figured I'd go ahead and get that out of the way. Dick Anthony Heller was a D.C. Special Police officer who was authorized to carry a handgun while on duty. He applied for a 1-year license for a handgun. He wished to keep it home, but his application was denied. Heller sued the District of Columbia and argued that they violated the Second Amendment right to keep a functional firearm in his home without a license. The district court dismissed the complaint. The U.S. Court of Appeals for the District of Columbia Circuit reversed and held that the Second Amendment protects the right to keep firearms in the home for the purpose of self-defense. The District of Columbia's requirement that firearms kept in the home be non-functional violated that right. Like I said before, it's only common sense. You would, in fact, want to have your weapon without a trigger lock on it. Anybody who tells you you need to have a trigger lock on it, just know that that is your personal. Like I said, if you want to have a trigger lock on your pistol, go right ahead. However, if you have more than one gun in your home, which, by the way, I advise people have, you're going to need a weapon that does not have a trigger lock on it because, let's be honest, crap happens and it happens extremely fast. I mean, what is it? 357 Magnum round travels, what is it? 1,300 feet per second, which is much, much faster than the police response time.
I mean, common sense has got to be taken into consideration here. So let's take a look at the question. Do the provisions of the District of Columbia Code that restrict the licensing of handguns require licensed firearms kept in the home to be kept non-functional violate the Second Amendment? Here's the conclusion. And before we get to the conclusion, we're going to go ahead and take a look at the actual justices involved in this case. So as you guys can see here, majority opinion by Antonin Scalia, Justice John Roberts, Scalia, Kennedy, Thomas, and Alito. Here are the ones that dissented: Souter, Stevens, Ginsburg, and Breyer. Just want you guys to go ahead and know that. Okay, so here we go. The ban on registering handguns and a requirement to keep guns in the home disassembled or non-functional with a trigger lock mechanism violate the Second Amendment. Justice Antonin Scalia delivered the opinion for the 5-4 majority. The court held that the first clause of the Second Amendment that references a militia is a prefatory clause that does not limit the operative clause of the amendment. Now, really quick, let me say this right now. Okay, I'm going to reread the Second Amendment for you guys. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall be infringed. Now, the key phrase, the right of the people to keep and bear arms shall not be infringed. That means that you, the people, are allowed to have this particular weapon. You are particularly allowed to have an arm. Let me reread this one more time. Not the full thing, but here we go. Additionally, the term militia should not be confined to those serving in the military because at the time the term referred to all able-bodied men who were capable of being called to such service. To read the amendment as limiting the right to bear arms only to those in a governed military force would be to create exactly the type of state-sponsored force against which the amendment was meant to protect. People. Now, remember something really quick. I may have kind of read that in a confusing way, but let me put it this way here. If the military is the only organization allowed to have guns, then that means that the military itself could very, very well become tyrannical and then immediately become a tool of the federal government. There have been several cases of the federal governments of other nations using the military against its people. It was the SS, and I want to say it was the Gestapo. They were rounding up people left and right, primarily Jews, right before World War II, and that was being done to collect firearms from people that they thought to be a possible threat. The Soviet Union did the exact same thing, but the Soviet Union's, in my personal opinion, deserves a separate project, which I'll probably bring it up when I did the remake of the Second Amendment project. Cuba, Castro did the exact same thing after their revolution. Basically, the idea, take the guns away from the people. They do not pose a threat, so therefore they're much easier to take the firearms away and take over. So let's see. Because the text of the amendment should be read in the manner that gives the greatest effect to the plain meaning it would have had at the time it was written, the operative clause should be read to guarantee an individual right to possess and carry weapons in case of confrontation. This reading is also in line with the legal writing of the time and subsequent scholarship, therefore banning handguns, an entire class of arms that is commonly used for protection purposes, and prohibiting firearms from being kept functional in the home, the area traditionally in need of protection, violates the Second Amendment. Now, let me say this really, really quick, though, before we get to Justice John Paul Stevens' dissent. Pew Research did some studying on this a long time ago, and they concluded, and as a matter of fact, the study always comes to be very consistent. Handguns are the gun that's commonly used in homicides or that's commonly used in deaths. However, here's the thing. A major percentage of that, roughly right around 2/3, are actually suicides. This is one of the reasons why I look at people when they scream and holler about shootings. I think to myself, you know what, man, blaming guns for all these deaths is almost like blaming misspelled words on your pencil. Okay, it takes a person to pull the trigger. The guns themselves do not shoot. I mean, if this is the case, why is it when we go to war, why don't we just send the guns? Why do we send people to operate the guns? There's a lot of common sense here. Okay, just figure out how to say this. Now, in his dissent, Justice John Paul Stevens wrote that the Second Amendment does not create an unlimited right to possess guns for self-defense purposes. Instead, the most natural reading of the amendment is that it protects the right to keep and bear arms for certain military purposes, but does not curtail the legislature's power to regulate non-military use and ownership of weapons. Justice Stevens argued that the amendment states its purpose specifically in relation to the state's militias and does not address the right to use firearms in self-defense. which is particularly striking in light of similar state provisions from the same time that do so. Justice Stevens also notes that people does not enlarge the protected group beyond the context of service of a state and a state-regulated militia. This reading is in line with the legal writing at the time that contextualized the amendment in relation to the to state militias and post-enact legislative history. Justices David Souter, Ruth Bader Ginsburg, and Stephen G. Breyer joined in the dissent. Justice Breyer also wrote a separate dissent in which he argued that the Second Amendment protects militia-related, not self-defense-related interests, and it does not provide an absolute protection from government intervention in these interests. You figure that judges who, by the way, were lawyers at one point in time, you figure that they would actually have a common sense understanding that it does actually say it in the amendment itself. Let me read it one more time. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. It says it right there in the second half that you quite frankly have a right to keep and bear arms, and that right there would also suggest self-defense. Yeah, it seems to me like it's much, much more politically motivated. So let's go ahead and try to finish this up. Historical evidence from the time of ratification indicates that colonial laws regulated the storage and use of firearms in the home. Justice Breyer argued that the court should adopt an interest balancing test to determine when the government interests were sufficiently weighty to justify the proposed regulation. In this case, because the interest balancing turns on the type of analysis that the legislature, not the court, is best positioned to make, the court should defer to the legislation and uphold restrictions. Justice Stevens, Souter, and Ginsburg joined the dissent. Now, speaking of the legislature, a lot of statewide legislative branches have, in fact, enacted some form of gun control, but what has it actually gotten them? The city of Chicago, which, by the way, we're going to talk about next, the city of Chicago has one of the highest crime rates, murder rates in the country. I mean, by God, they've had riots here recently. If people were allowed to own a gun, I'm pretty sure that a lot of this crime would be somewhat curbed. Same exact thing with New York City, same exact thing with Philadelphia, same exact thing with most major cities, especially Los Angeles. If people were allowed to carry a firearm to defend themselves, a lot of this crap would be completely avoided, especially riots. It would be a massive deterrent. I just figured I'd go ahead and throw that out there. The real reason why they want to enact some form of gun control is because gun control at the end of the day is good old-fashioned people control. Now, guys, with that right there being said, you pretty much can already see right here what the conclusion was. The conclusion basically said that you can keep a firearm in your home for self-defense purposes. Okay, like I said, here's the question. Do the provisions of the District of Columbia Code that restrict the licensing of handguns should require licensed firearms kept in the home to be kept in a non-functional violate the Second Amendment? The conclusion, as I mentioned earlier, said that you can have a firearm in your house, and it also states that it does not have to be non-functional. I mean, dude, why would you have a non-functional weapon in your home? I mean, unless you plan on bludgeoning someone to death, which, by the way, is another way of killing someone, is by way of bludgeoning. I oftentimes argue with left-wingers that shooting somebody is not the only way you can kill somebody. As a matter of fact, before I go any further, this same argument kind of equates to another argument. Do you guys remember the video game The Last of Us? Do you remember how at the end people kept on saying that Joel was wrong for not letting Ellie die, and that the way that they should have allowed the vaccine to occur? You have to watch your words here because YouTube has this way of doxing certain words and doxing certain videos, when in fact the infection that came from the infected was actually the least of your worries. You see, if you recall that video game, when they actually bite you, they don't really so much just infect you, they also rip your throat out. So while your throat is pulling out of your head, what are you going to do? You're going to look at everybody and say, hey, look, guys, I'm immune. I had it. I'm not going to die. No. You're about to die. You see what I'm saying? There are other ways to die. Okay, I just figured I'd go ahead and throw that out there. Now let's go ahead and get to the next case. Here we go again with, McDonald v. Chicago. Now, like I said, guys, there will obviously be more than one link discussing these particular cases, so that way you guys can kind of come away with your own interpretation. But once again, though, this right here is probably the simplest breakdown that I've ever seen of it. And some of these cases, of course, are in fact complicated. I found this out when I went through paralegal school, that the legal matters can actually be, in fact, extremely complicated. So let's take a look at this. Facts of the case. Several suits were filed against Chicago and Oak Park in Illinois challenging their gun bans after the Supreme Court issued its opinion on the District of Columbia versus Heller. In that case, the Supreme Court held that the District of Columbia handgun ban had violated the Second Amendment. There, the court reasoned that the law in question was enacted under the authority of the federal government, and thus the Second Amendment was applicable. Here, the plaintiffs urged that the Second Amendment should also apply to the states. The district court dismissed the suits on appeal. The U.S. Court of Appeals to the Seventh Circuit affirmed. Now, yes, I'm smoking while I'm doing this. Does the Second Amendment apply to the states because it is incorporated by the 14th Amendment privileges and immunities or due process clauses and thereby made applicable to the states? Speaking of that 14th Amendment, there will be bits and pieces from a documentary in part 2. I'll try to do the best I can with copyright from a documentary that was made back in 2013 by Chris Koenig called Assaulted, Civil Rights Under Fire. You can watch it on Amazon via the Tubi or the Roku app. I advise you guys go check it out. It is, for the most part, narrated by Ice-T, who does do a very good job of narration, in my opinion. I advise you guys go check it out. And, of course, the topic of Hurricane Katrina, Waco, and, of course, Ruby Ridge will also be mentioned as well. So, what was the conclusion of this case? The Supreme Court reversed the Seventh Circuit, holding that the 14th Amendment makes the Second Amendment right to keep and bear arms for a purpose of self-defense applicable to the states. With Justice Samuel A. Alito writing for the majority, the court reasoned that the rights that are fundamental to the nation's scheme of ordered liberty, or that are deeply rooted in this nation's history and tradition, are appropriately applied to the states through the 14th Amendment. The court recognized in Heller that the right to self-defense was one of such fundamental and deeply rooted right. The court reasoned that because of its holding in Heller, the Second Amendment applied to the states. Here, the court remanded the case to the Seventh Circuit to determine whether Chicago's handgun ban violated an individual's right to keep and bear arms for self-defense. Now, let me say this before we get to Justice Alito. This right here is actually a bit of a revelation. I want you to think about something really quick. Right now, the state of Tennessee is trying to enact red flag laws. Okay, the red flag laws that they are trying to enact are, in fact, on a certain community that committed a shooting a while back, recently. Actually, when I say a while back, it's been a few weeks. So, I got to ask the question, has the Democratic Party painted themselves in such a very bad corner that they cannot challenge the ruling? Now, you can obviously challenge the ruling in the Supreme Court. However, here's the thing. If you challenge the ruling, then what does that say about your party? Isn't your party extremely progressive? Isn't your party all about gun bans? So, obviously, you'd be quite hypocritical. I just figured I would throw that out there. I mean, it's just a bit of a revelation that kind of hit me because the 14th Amendment is supposed to basically apply to equality. Just figured I'd throw that out there. Justice Alito, writing in the plurality, specified that due process clause of the 14th Amendment incorporates the Second Amendment right recognized in Heller. He rejected Justice Clarence Thomas' separate claim that the privileges or immunities clause of the 14th Amendment more appropriately incorporates the Second Amendment against the states. Alito stated that the court's decision in the slaughterhouse cases rejecting the use of privileges or immunities clause for the purpose of incorporation was long since decided, and the appropriate avenue for incorporating rights was through the due process clause. Justice Antonin Scalia concurred. He agreed with the court's opinion, but wrote separately to disagree with Justice John Paul Stevens' dissent, and Justice Clarence Thomas concurred in the judgment. He agreed that the 14th Amendment incorporates the Second Amendment against the states, but disagreed that the due process clause was the appropriate mechanism. Instead, Justice Thomas advocated that the privileges or immunities clause was the more appropriate avenue for rights incorporation. Justice John Paul Stevens dissented. He disagreed that the 14th Amendment incorporates the Second Amendment against the states. He argued that owning a personal firearm was not a liberty interest protected by the due process clause. Then again, though, these people are obviously a bunch of communists, too. We already discussed that when it came to Heller versus D.C. Let's see what else we got here. Let's see. He argued that owning a... I already read that. Justice Stephen G. Breyer, joined by Justice Ruth Bader Ginsburg and Sonia Sotomayor, also dissented. He argued that there is nothing in the Second Amendment's text, history, or underlying rationale that characterizes it as a fundamental right, warranting the incorporation through the 14th Amendment. Now, John Paul Stevens would eventually be replaced by Justice K. Hagan. That occurred during the Obama administration. It's one of the main reasons why we need to go back to 60 justices appointing Supreme Court. But then again, though, if you want to blame somebody for that, maybe you should blame Harry Reid, who is the one that basically lowered that provision down to 51. Of course, Mitch McConnell did, in fact, advise him, or at least tell him that he would live to regret that. As a result of this, now we have Amy Coney Barrett. Now we have Brett Kavanaugh, who I'm still am not very much sold on. And, of course, now we also have Neil Gorsuch. Fact of the matter is we have a much, much more conservative Supreme Court. And, of course, it typically tends to override this particular individual down here who always finds a way of screwing conservatives over. The great Justice Antonin Scalia, the great Justice Clarence Thomas, who, by the way, I do disagree with him on this case, but still Clarence Thomas is one of my favorite Supreme Court justices of all time. Kennedy, at one point in time, was considered to be the swing justice, and Roberts, believe it or not, was not considered that way. But obviously, we are now finding out today that oftentimes people can kind of interchange their positions. Let's go ahead and wrap this video up, guys.
Consistent and unprecedented obstruction by the Republican caucus has turned advise and consent into deny and obstruct.
Look, if advise and consent is to mean anything at all, occasionally consent is not given. But by any objective standard, Senate Republicans have been very, very fair to this president.
Is the Senate working now? Can anyone say the Senate is working now? I don't think so.
If you want to play games, set yet another precedent that you'll no doubt come to regret. Say to my friends on the other side of the aisle, you'll regret this, and you may regret it a lot sooner than you think. In other words, they believe that one set of rules should apply to them, and another set to everybody else. He may just as well have said, if you like the rules of the Senate, you can keep them. Huh? If you like the rules of the Senate, you can keep them.
Reach in the U.S. Senate today, where Republicans have been holding up nominations that President Obama has made to federal judgeships. Democrats accuse Republicans of abusing the filibuster rule to hold up these appointments. And they point out that half of all filibusters against presidential nominations in U.S. history have happened just in the Obama administration. Well, today, Democrats pushed through a change in the filibuster rule that was so unthinkable, it was nicknamed the nuclear option. Nancy Cordes has the fallout on Capitol Hill. Nancy?
And Scott, leaders from both parties have threatened to deploy this nuclear option for decades, but until now, they have never followed through because it fundamentally alters the way the Senate works.
The Senate's Democratic leader, Harry Reid, said the final straw came when Republicans blocked the president's 3 nominees to the U.S. Circuit Court in Washington, D.C.
The obstruction we've seen from Republicans against President Obama has reached new heights never dreamed of.
So he called all 100 senators to the floor and announced he was changing a 96-year-old rule, lowering the hurdle for confirming appointees from 60 votes to a simple majority of 51 votes. All but 3 Democrats voted to change the rule.
The yeas are 52, the nays are 48.
The furious Republican leader, Mitch McConnell, argued Democrats were simply trying to shift attention away from Obamacare's disastrous rollout.
So yeah, I'd probably be running for the exit too if I'd supported this law. I'd be looking to change the subject.
The new rule only applies to executive branch and lower court nominees, not Supreme Court picks or legislation. But Republicans say it's a slippery slope.
Leader Reid, won't this come back to bite you when you're in the minority? What if they have a nominee you think is unsuitable?
What I said on the floor, what I've told these few, this is the way it has to be. The Senate has changed.
Reid came close to deploying the nuclear option this summer until a bipartisan group led by Senator John McCain cut a deal to let some long-standing nominations go through.
Was there any talk of a similar deal this time?
Yes, I did. They basically said there was too much pressure from many of their members.
There are 76 nominees awaiting confirmation, but the Senate didn't exactly get to work voting on them, Scott. Instead, they took a 2-week recess, so they won't be back until December under a cloud of bad feelings.
I threw that last little bit in there of Harry Reid and Mitch McConnell and what happened back in 2013. You see a lot of people, mostly Democrats, they love to bring up the topic that Trump, he eliminated the filibuster, so why the hell can't we do it? Well, dude, if I recall correctly, it was actually Harry Reid and Obama who got rid of the filibuster. And the reason why they got rid of the filibuster in real life was not just for judicial appointments. They wanted some murky road there so that way they could pass through legislation. See, Barack Obama, and I said this in a previous video that I did, he was not a good politician. Clay Travis is 100% wrong on that. He only says that because he voted for the guy twice. I mean, dude voted for Gary Johnson, and yet somehow or another he is a conservative commentator. Yeah, replacing the late great Rush Limbaugh. Let that sink in. These are the people who were telling you to which candidate to choose. You never let liberals choose your candidates. Makes you almost wonder if there was a plant in there somewhere, but we'll talk about that in another video. Fact of the matter is this right here. The Senate filibuster game has been played a lot, mostly started by Obama. Of course, you guys saw that from 2013. Now, why am I bringing up the filibuster? Well, you see, it's the filibuster rule that they constantly use against Republicans for obstructing any type of gun legislation. The truth is this right here, though. A lot of Second Amendment lawyers, a lot of pro-2A groups have been winning court cases in the Supreme Court against the federal government, mainly the radical left. There was the Bruin case. There have been several decisions since. There was also that Fourth Amendment case recently. So you have to keep up the actual honest-to-God fight. But technically, they cannot take away our firearms. They can legislate things away, but even that there is unconstitutional. Now, I don't know if I said it before, but let's just say that somebody tried to put some form of gun control in place, like a bill of attainder, like you saw earlier, try to take away the guns from someone. That right there would immediately be tossed out in court. And the first state, of course, that would in fact sue would be the state of Texas, because the state of Texas automatically has a direct line to the Supreme Court. So any way that you cut it, any way they try to go through with it, yeah. And also something else too, you have to consider people are not just going to hand them over. Look, you have on estimate anywhere between 90 to 95 million gun owners in the country. And we'll talk more about national registry and all that stuff there. We'll talk more about that in parts 2 and 4. The thing you have to understand is this, and part 3 as well. The thing you have to understand about that is good luck trying to get them. You have close to 400 million total guns in the country, and people can actually make those firearms. I'm an extremely pro-Second Amendment guy. I try to keep up with this stuff the best I can. Then again, there are channels out there, Mr. Guns and Gear for one. There are armed scholars. You've got armed attorneys. A lot of these guys are very good, much better than myself. Coleon Noir is probably my personal favorite one to listen to. The thing is this right here, though. You can't take the guns away, not legally, nor even illegally, meaning logistically, but that does not mean that it will not try. Why do you guys think that they're using the ATF to pass, to go through with stuff like, brace bans, what else you got, FRT bans, typical nuisance type stuff, of which, by the way, we will be discussing a lot more in the next few parts. Fact of the matter is they keep putting annoyances in place so that way people will eventually give up. But they obviously underestimate their own people. You see, when I said 95 million gun owners, it's probably really closer to about 100 to 120 million, because God knows how many people have one that's already been handed down, or have, how we could say, has been grandfathered in. That's one of the main reasons why I wanted to leave this thing off with the bill of attainder, because obviously we do not have bills of attainder. And once you have banned something, you can't make it illegal after the fact, meaning that, you can't actually physically take it from the person. Which brings me to bans. You see, the number one thing that Democrats want is they want an AR-15 ban, and they want a gun registry. Now, like I said before, we're talking about a gun registry more in parts 2, 3, and 4, because a national gun registry is pretty damn dangerous. And I'll be giving you guys some more historical context in those videos there. But here's the thing I need to say, and it's the same exact thing with bans, and of course with confiscation too. You got 95 million gun owners in the country. You've got roughly 400 million guns total. People have got the ability to make weapons legally by state law. I think we can here where I live at as well. It's going to be an extremely impossible task for you guys to take. Like I said, this is the reason why they keep putting stuff in place like a brace ban, FRT bans, getting rid of certain pieces of equipment that you can mount on your weapon. That's the reason why they do it. They do this crap to create any type of annoyance, any type of inconvenience that they can throw, I mean, any type of inconvenience imaginable on the American people. I know I'm kind of stuttering and stammering here, but that's why they do this crap. They do this crap to be an additional annoyance, to throw an additional annoyance on your life. They also do it for another reason, too. You see, what they're hoping is that you will go find a lawyer and you'll spend all your money to keep said one piece of item. They do this crap to actually affect poor people because it's people who are, let's just say, more working class that are, in fact, the gunners. Who, by the way, the working class is actually the major bulk of the country's population. So remember that. Also, to go on top of this, they don't want you to have anything similar to what the military has. Now, guys, let me go ahead and say this right now. If you actually look at the statistics when it comes to guns itself, most gun-related deaths are, in fact, suicides, and they're done with handguns. Also, something else, too, there's a mass shooting every day, sometimes multiple mass shootings every day in America's largest cities. Mostly black-on-black crime, and, of course, these areas include Chicago, New York, Philadelphia, which, by the way, have some of the strictest gun laws in the country, some of the strictest gun laws known to man. And yet we never hear about this in the national news. We only hear about this in the local media, and we have to find out online. Fact of the matter is that the federal government, the mainstream media, well, you can go ahead and call it the media and the federal government, they don't tell you what the law is. They don't tell you what the Constitution is. They tell you what it should be. These people believe that the U.S. Constitution is a living, breathing document that changes and ebbs and flows with time. That is not the case at all. And one more thing, too, to the crowd that says that the Second Amendment only applies to muskets and crap like that. It says the right to bear arms, not muskets. It does not say rifles. It says arms. And also, one more thing, too, it's still legal to own a cannon in a few states. Just figured I'd throw that out there. Which brings me to my last point. Now, guys, let's talk a little bit about legislation here. And I know I probably should have led with this right here, but here's the thing. Legislators themselves, and this is one of the reasons why I wanted to show you guys what I showed you back from 2013. You see, a lot of these lawmakers will come up with something and then they'll go away for like 2 weeks. It's why the federal government typically does not scare me. They just don't. It just seems to me like they have a bunch of lazy people in there who are just trying to keep their seats warm and collect that extra cash. This is what I've been saying for a long time, that what they've been trying to do is they've been trying to slowly but surely give us socialism, but when Bernie Sanders came on the scene, he kind of effed things up for them, and he tried to accelerate the process, and they kind of underestimated the movement that they had. They felt that Barack Obama's own perceived popularity would get them through in 2016. I'll try to leave this video right here in the description box for you guys, so that way you guys can see what Mr. Senior Razorfist says about how Obama obliterated Hillary. So, here's the deal. Anytime somebody tries to legislate, and by the way, Obama was very, very much in favor of gun control. Let me go ahead and say that right now. But Obama was so lazy, and you guys will see it in that video there, of which I actually read that book that Ed Klein wrote, that even his own party could not get behind him. As a matter of fact, it was Dianne Feinstein's AR-15 ban, and I want to say there was even a confiscation provision in there. Her own party would not actually go along with it. But then again, the Democrats would more than likely have never gotten 60 votes in the Senate to actually get that done. It's also another reason why, as I mentioned earlier, that Barack Obama wanted the filibuster to occur. Harry Reid was not acting on his own. Harry Reid was being told by Barack Hussein Obama what to freaking do. Now, in the case of the 1994 crime bill ban, they had to get some Republicans to go along with it. Weak-kneed Republicans. We also had that in the last gun bill, where we had 10 cross the line to join the Democrats on this issue. And I'm like, you people are absolutely freaking useless. I mean, so make sure you guys keep up with your representatives and make sure to vote them out anytime they actually, let's just say, do you over.